these are patentable, but if not, then this set of claims really is patentable. So it's kind of like two separate arguments, and that's how they set up the oral hearing. So let's go into the tips for handling these post-grant reviews. And this pertains to both covered business methods and IPRs, but for the most part I'm talking about IPRs, and that's the majority of cases that have been filed to date. As I mentioned earlier, for the petition, you might want to consider filing multiple petitions because the PTAB is only granting trial on about 30% of your proposed grounds. So if you propose 10 grounds of rejection, it's likely you're only going to get trial on 3 or fewer of those. For the patentee, do you want to file a preliminary response? It adds to the cost, but you have 60 pages in a preliminary response, and if you can direct the PTAB to a certain decision, then why not? But you know, the statistics do show that it is beneficial at this point, although there's really not a statistically significant number of cases yet to make that determination. But it does seem that the granting on the percentage of proposed grounds is about the same, whether the patent owner files a preliminary response or not. In other words, the PTAB grants trial on about 30%, regardless of whether you file a preliminary response or not. Where it makes a difference, it seems anyway, so far, is in the actual denial. And it seems like you have a better chance of getting the whole thing denied if you file a preliminary response. I'll then talk about amendments, how limited it is, how you have to explain each claim is patentable, and you can't just come in and say, well, it's not disclosed in the prior art that you have presented. You've got to, there's a lot more you have to explain. You're limited to 15 pages, double-space, 14-point font. So there's a lot of restrictions on amendments, and I'll talk about some of the recent decisions and orders that the board has set out. And finally, discovery. Again, limited. Everything's limited at the PTAB because they only have a year to handle these. This is why they're denying grounds as cumulative. This is why they're saying you're limited to 15 pages. This is why they're saying we only want a few claims, substitute claims, one-on-one. This is why they are precluding discovery like you get in district court, where you have a set of interrogatories and a set of document requests with 10 pages of instructions before you even get to a document request. The board doesn't want to see any of that. So here are some tips for petitioner. As I mentioned, the PTAB is not granting trial on many of your grounds. I have 33% is the new statistic for this month, which kind of climbed up a little bit from a few months ago. And we've talked earlier about the possible estoppel effects, because you're estopped in litigation or later, even in another patent office proceeding, from arguing on patentability on a claim that has received a final written decision on any ground that was raised or reasonably could have been raised. And if it's denied because cumulative, you're still going to get, you still may get a written decision on a claim and that your cumulative rejection applies to, and you obviously could have raised it. You did raise it. Are you precluded? Are you estopped statutorily, or just as a matter of legal argument? Perhaps, perhaps not. But why take the risk? Why not present maybe at most 5 grounds in your petition? Focus on one single primary document, and then either anticipation or obviousness, and limit it to a limited number of grounds and a limited number of prior art documents. From what I've seen, if there's 20 different documents with 18 separate proposed rejections, the board typically only grants it on 1 or 2 and focuses on 1 or 2 pieces of prior art. Keep it simple. I've also seen a number of cases denied where you have multiple pieces of prior art. You're proposing a convoluted obviousness argument, based on 5 separate references where, you got 6 elements in the claim and each one is known somewhere else, and it's this crazy convoluted argument that you probably used to be able to get away with in inter-parties re-exam. It's not going to happen in inter-parties review. So they typically will deny any type of convoluted type argument that's difficult to follow. Expert needs to be qualified and needs to support all the conclusions. I've already seen 2 denied because the expert did not present all of the underlying bases for the calculations, just said, hey, I measured this and here's the number and that falls within the scope of the claim, but didn't say how it was measured or how it was calculated. And for the petitioner, your petition is your best opportunity because the next chance you have to reply is only going to be after the patent owner response, and then you're limited to 15 pages. So it's important to get everything out there and get it right the first time. All right, so for the patentee, should you file a preliminary response? This has been a pretty big issue, at least for me, because it adds to the cost, and a preliminary response can be pretty lengthy. But there's some limits on it. You can't submit any new extra evidence, but we'll talk about that in a minute. But I looked at the statistics, and when the patentee or patent owner files a preliminary response, petitions are granted about 84% of the time. But when they don't file them, they're granted about 95% of the time. So it seems at least, but again, we don't have enough cases yet for this to really be of any significance, and 2 more denials could completely skew these numbers the other way. But this looks like the only area where it might make a difference, because it's about the same with respect to the percentage of the grounds that are denied, regardless of whether you file a response or you don't. And I've had both situations, one in which I filed a response, and I can't remember how many grounds were proposed. I think there were 17 or so, and the board has granted trial on only 4 of them. And others where I filed a response, and I got about the same percentage of grounds that were granted. So I don't know if it benefits you there, but it seems to benefit you a little bit with the denial. So if there's something in the petition that is fatally flawed, for example, the declaration, or there's a teaching away, then a preliminary response is a good idea. Some common mistakes I've seen is some people don't think you can even file any evidence, and I've seen a lot of arguments against any evidence submitted, and that's not what the rules and the statutes say. You just can't file newly created evidence. In other words, you can't go out and find an expert and have them create an affidavit or a declaration and file that in your preliminary response. But you certainly can file a declaration or affidavit that was filed in the patent application prosecution history. You can submit that as evidence. You could submit prior art. Like I said, prior art that teaches away. If you're aware of a reference, you can submit that, even though it's new to the proceeding. It wasn't newly created for it. It just is new, and it's evidence that I think the board would find beneficial. Another thing you might want to think about as the patentee is try to anticipate what grounds the PTAB is going to grant trial. By looking at a lot of the cases in which they have granted or not granted, you can kind of get a flavor for what the PTAB is going to do. And if there are, for example, 3 or 4 anticipatory pieces of prior art that the petition alleges anticipate the claims, the board's likely going to look at the best one of those 4, or maybe 2 of them at most. And that's where they're going to focus, and they're going to give you, they may grant trial on an anticipation ground if they think it satisfies all the elements of the claims, and then typically we'll have another ground of rejection that proposes an obviousness based on that same piece of prior art and another document. And so you can focus your preliminary response on that particular, what you think is the most important, what you think the board is going to grant trial, and kind of steer them in a different direction if you can. Obviously, if you're involved, if the patent is involved in litigation, you are somewhat restricted in your ability or willingness to amend the claims. Many times you don't want to for intervening rights and past damages, so you typically try not to do that. But if there's no litigation, certainly amend the claims if you can, and but the amendments are limited, and we'll talk about that. Another thing you can do is attack the petitioner's expert, and you can do that in the preliminary response if you want to, either by not supporting the data, by not satisfying all the requirements for evidence, or whatever basis. Maybe he's not qualified to testify as a person of ordinary skill in the art. All right, so I'm going to switch gears and talk about amendments to the claims. You are guaranteed, supposedly, the right to amend the claims. The patent owner does not need the PTAB's consent to file a motion to amend, but the rules basically say that, look, even though you don't need our consent to file a motion like you do for all these other motions, we do want you to call us and confer with us. And the reason they want you to do that is so they can kind of walk you through what they're looking for in a motion to amend, so that you don't file your motion a month and a half later, they deny it because you didn't cross the T and dot the I the way they wanted you to, and now you're back to trying to do it all over again, and it's wasted 2 or 3 months of everybody's time. So you need to call them, confer with them, opposing counsel will be on the phone with you. The problem with amending the claims is there's a lot of limitations to it, and you're typically only going to have one opportunity to do that. There's a case that was decided a while ago. It's Idle-Free v. Bergstrom, and it's IPR 2012-27, paper 26. And this is what the board always cites when you say you want to amend the claims. They'll cite this to you and say, hey, you better read through this decision. And at the bottom here, you can see this link I've provided. That link is a link of representative orders and decisions by the PTAB in covered business methods and IPRs. And you'll find this there as well as some of the other ones I'm going to talk about. And that's where they put decisions that they then will rely upon later in other unrelated cases, and they just refer to it. They say, hey, for all the time limits to respond to a motion for pro hoc vice, go to this order. And you have to go to this website, find the order, read it, and you'll find out everything you need to know from there. So in this case, they talk a lot about what you need to do when you file a motion to amend the claims. Some of the things you need to do are, first is the substitute claim, and it's not an amendment, right? You don't file what you file in ex parte prosecution where you amend claim 1. You would file, if you have 20 claims in the patent, you would file a substitute claim 21. And you'll tell the board that that is a substitute for claim 1. That claim, that substitute claim, has to be responsive to a rejection. So, you're not just cleaning up the claim because there's a couple of typos and it doesn't read correctly, which is improper in an IPR, although proper in a CBM. And you cannot broaden. So if you are, for example, combining claims 1 and 3, claim 3 wasn't in trial, and you're not worried about the limitations of claim 3, you think they're great and they're patentable and you're happy with it, you could file a substitute claim that's essentially a combination of those two, but you can't delete anything from the claim. Like, for example, say claim 3 said, substantially something or other. And when you combined the two, you got rid of the word substantially. The PTAB is not going to let you do that. There's a clear presumption of only one substitute claim for each challenged claim. So if there's 10 claims that are challenged, you're pretty much only going to get 10 substitute claims. You're not going to get 20 or 30. And, if you want a whole new hierarchy of claims, the board has said in a number of these orders that, you have an opportunity to do that. Once trial is granted, the patent owner, if they want to go the amendment route and completely change their claims, they can file an ex parte reexamination request, and in the ex parte reexamination, go through the whole process. That sounds interesting. I just don't know procedurally how the PTAB is going to handle that, whether they will stay the IPR pending the outcome of the ex parte reexam, because they're limited by statute. They have to have a final written decision within a year or 18 months. And there's no chance ex parte reexamination is going to be done by then. You have to identify the challenged claim that's intended to be replaced. So if your substitute claim is 21, you have to tell the PTAB that you're intending to replace claim 1. So claim 1 still exists until the whole trial is over and appeals and everything. Claim 21 is one that you intend to replace claim 1. So you have to tell them which one, and you have to show a patentable distinction based on the substitute claim. So what does that mean? You have to show that substitute claim is patentable over the prior art. You also, in some circumstances, if you're going to have more than one substitute claim for the same claim, so if 21 and 22 are both substitute claims for claim 1, you have to show how 21 is patentable over all the other claims as well as claim 22. And for 22, you have to show why that's patentable over all the other claims plus 21. And even in some other circumstances, they may require you to argue that a substitute claim is patentable over another challenge claim. The burden is, this is the interesting part, the burden is on the patent owner to show patentability over the prior art of record. And if there's prior art not of record but known to the patentee. So this comes into that, and I can't remember the rule number. Probably should have looked it up before the call. But there's a rule number a rule that says if you're aware of any evidence that is contrary or takes a contrary position to something that you are arguing, you have to bring that to the attention of the board. And that's in line with what they're saying here. So you've got to argue that it's patentable over the prior art of record and any prior art that's not of record but known to you. You got to identify the feature that's added to the claim that makes it patentable and explain why. So if you added an element to the claim, element E, for example, you have to explain why that element is patentable, and the significance of that feature must be from the point of view of a person of ordinary skill in the art. And so I cite another IPR decision where they talked about that. That's in the AIA v. Network Security. A conclusory statement, which you can get away with and sometimes in re-exam and ex parte prosecution, and a conclusory statement that just says, hey, the added features are not described in the prior art, even if it's true, is not sufficient. They're not interested in having you come in and say, hey, look, I've added element E to the claim, and element E is nowhere in the prior art. They want you to tell them why element E is important and why it's patentable over all the art. The other thing you need to put in your motion to amend is you have to provide where in the original disclosure each claim is supported. And this is another representative order that's in the Nichia v. MCOR case, IPR 2012, number 5, paper number 27. And you'll find that at the same link I provided earlier. You have to show support in the application, which is interesting, not in the issued patent. So you would go back to the application and provide perhaps paragraph number or page and line number as opposed to column and line number in the patent, unless you can indicate and show that there was no change to the original disclosure, which for many cases will probably be true if no amendments or significant amendments were made to the specification. Citations to the provisional application are not relevant, at least for written description purposes, according to the PTAB. For this particular exercise, like your claim is supported by the original specification as filed at the Patent Office, you would need the provisional support if there was an intervening piece of prior art that you needed to get around. Then you have to show it, but not for just showing that the original disclosure supports your claims. And so I just took a quote out of one of the decisions, that a mere citation to the original disclosure without any explanation as to why a person of ordinary skill in the art would have recognized that the inventor possessed the claim subject matter as a whole may be inadequate. So I don't know if they're hinting here that they want an expert, you know, to opine that, hey, a person of ordinary skill in the art would have known you had possession of the subject matter disclosed on, you know, page 6, lines 10 through 14. Who knows? But if you just say, hey, it's supported and here's the citation and that's it, the PTAB said that that's not going to be enough. Another interesting thing about your motion to amend is it's limited to 15 pages. There's another decision that's fairly recent in an IPR, Inulux v. SEL. 15-page limit was strictly enforced. The patent owner argued in that case and said, you know, my claims are really long. I've got a long claim, and I have to put in my motion, and all my papers have to be 14-point font, double-spaced, and the claim has to be 14-point double-spaced. I'm going to use up 13 of my 15 pages just putting my substitute claim in. And the PTAB said, tough. 15-page limit is 15-page limit. And not only do you have to put the claim in there, your substitute claim, you have to describe where it's supported and explain why it's patentable, and you have to do all of that in 15 pages. So, you know, and again, they say, hey, look, this is not like ex parte prosecution. This is more of an adjudication type thing, legal proceeding like litigation, where you're not permitted to amend. So amendments are very limited, and the board has taken a very limited view toward that. And like I said, in a couple of these decisions, in their orders, they've said there are other avenues you can pursue if you want, you know, to wholly revise your claims, like ex parte reexamination or reissue. All right, let's switch over to discovery. Just like your amendments, discovery also is limited. It's certainly not going to be as broad as district court litigation. One of the decisions that the PTAB will always cite whenever you are asking for permission to file a motion for additional discovery, and by the way, you don't have to ask for discovery that's called routine, but if it's additional, you do. So, and I talk a little bit below, like a deposition of a witness, like the expert that was relied upon in the petition, you don't need to go ask the board for a motion to compel the witness to testify. The other side is supposed to proffer them for testimony, and you don't need the board's permission. But for additional discovery, you do, and they'll cite to the Garmin v. Cuso case, and that was the first oral, that was the oral argument we just talked about in the IPR. And there, the board, the PTAB, set out all the different things you need to do for a motion for additional discovery. So they talk about, right, discovery. You have your routine discovery, and then the additional discovery is what's considered what is otherwise necessary in the interest of justice. And what's interesting is this language is different for covered business method than it is for IPR. And I can't remember exactly what the language is in covered business methods, but apparently it's a different standard for CBM, or for which is post-grant review as well, as opposed to inter-parties review. But what does the interest of justice mean? Well, that's what the PTAB tried to set out in this Garmin v. Cuso order. There's 5 factors they talk about, and they've mentioned this in a couple of cases. So in order to get this additional discovery, you have to show that it's more than a possibility and mere allegation. The PTAB has said that the mere possibility of finding something useful and a mere allegation that something useful will be found are insufficient to demonstrate that the requested discovery is necessary in the interest of justice. So the party that's requesting the discovery should already be in possession of some evidence that tends to show, beyond speculation, that in fact something useful will be uncovered. This usually can happen if you're in litigation and you've already had some discovery, and so you have an idea of what's out there. You know that petitioner's evidence shows certain things, and you actually have access to some of these documents. You can request discovery of those documents. You could ask for the specific documents. You could ask for a little bit more, but you need to be specific. You can't just present a motion for additional discovery that looks like your typical first set of document requests in litigation. It's not going to happen. The second factor is that litigation positions and underlying basis are not necessarily going to be discoverable. So if you ask for the other party's litigation positions and underlying basis for those positions, what the board is saying is, you know, that's not really necessary in the interest of justice, and they've established rules for the presentation of arguments and evidence, and there's a proper time and place for each party to make its presentation. So a party cannot attempt to alter the board's trial procedures under the pretext of discovery. So they typically don't allow you to ask for that. If you have the ability to generate equivalent information by other means, they're not going to permit discovery. So information that a party can reasonably figure out or assemble without a discovery request would not be in the interest of justice to have produced by the other party. And they say in that connection, the board would want to know the ability of the requesting party to generate the requested information without the need for discovery. Obviously, if it's documents that you don't have and the other party does, then that should suffice, for at least for this factor. All right, so the fourth factor is easily understandable instructions. And this is where you're going to differ from litigation, obviously. The question should be easily understandable, and then they have an example. For example, 10 pages of complex instructions for answering questions is prima facie unclear. Such instructions are counterproductive and tend to undermine the responder's ability to answer efficiently, accurately, and confidently. And this is what you see in litigation all the time. You know, 8 pages of instructions on how to answer the document request. If you submit that before the PTAB, they're going to deny your motion. And then the final factor is the request has to not be overly burdensome for the other party to answer. Given the expedited nature of these proceedings, that's why they have this. The burden includes financial burden, burden on human resources, and burden on meeting the time schedule of inter-parties review. So the request should be sensible and responsibly tailored according to a genuine need. So what I had just done was I read for you what is in that CUSO decision, and that same language has been cut and pasted into a couple other orders. Now the PTAB just refers you to this decision and says, hey, if you're going to file a motion for additional discovery, go look up at this case and see what you need to do to file it. So I thought what might be useful is to maybe go through some samples of motions that have been granted and some samples of motions that have been denied. So here's one where the PTAB granted a motion. This was Corning v. DSM, IPR 2013-43, paper number 27. Here the patent owner was seeking discovery of underlying data, procedures, and et cetera that were used by the expert in reproducing prior examples to show anticipation. So in that case, Corning went out, took the prior art examples, reproduced them, generated whatever they generated. I can't remember if it was a polymer or what type of chemical it was, and tested it and found that it satisfied the elements of the claims, and therefore their argument was that prior art anticipated. DSM filed a motion for additional discovery and said, we want to know what the expert did to reproduce those examples so they can make sure that it was all done properly. And the board granted that discovery. It was very specific, it was specifically tailored and narrow, and they granted it. In another case in which they granted additional discovery was Bloomberg v. Markets Alert, Covered Business Method 2013-5, paper number 32. They allowed discovery of all documents that were considered by the expert, but only to the extent of the expert's recollection. So what they were looking for was, typically in an expert report, they'll have a bunch of exhibits, and those exhibits usually are all the documents that the expert considered, but maybe not all. And I think it was Markets Alert that filed the motion here, had some reason to believe that the expert on the other side relied on some other documents that weren't listed in the expert report. And they asked for it, and they weren't given it, so they had to file the motion. And the PTAB granted them, at least with respect to that aspect, they granted the motion, but they did deny discovery of licensing information and prior art. They also wanted to know, hey, tell me all the prior art that you're aware of. And the PTAB said, no, you're not going to get that. And they also wanted any licensing information. They didn't permit that discovery. All right, so here's a sample of a denied motion. It was in the Microsoft v. Proxicon, IPR 2012-26, paper number 32. The patentee wanted information related to commercial success of the petitioner's product that it tried to obtain, but the petitioner wouldn't produce it. So Proxicon was a patentee, wanted to make an argument of commercial success based on Microsoft's product, and they alleged that their product infringed, and that was part of the infringement case. And they wanted to base their commercial success off of the infringers or alleged infringers' commercial success. But Microsoft opposed and said, well, first of all, there hasn't been any adjudication of infringement. You don't know that this product infringes, and then you have to have some type of nexus. So the board said, I agree. The patent owner can get discovery if they can show this nexus between the information they sought and the allegations of commercial success, so that the commercial success was actually attributable to the patented product. They filed another motion, but this one wasn't sufficient and didn't provide a sufficient nexus for the board, so the board denied it. So as I finish all of these, I'm going to finish this one with the facts and statistics. These are facts and statistics as of Monday, August 19th. And by the way, the Patent Office actually publishes some statistics. It's not all the same ones that I have, but there's interesting ones in there. They actually break it out by art unit, or at least technology center where they're filed, and it as of, and they do it by the end of the month at least, it was end of July, like 70% of IPRs and I think CBMs were from the electrical technology center, which I found interesting. So most of these are in the electrical arts. As of Monday, 430 IPRs were filed and 42 CBMs. And when they proposed the rules, I think they had estimated about 440 IPRs would be filed each year. They also estimated a couple hundred to 200 or more covered business methods. So the covered business method is still way, way under their estimation, but the IPRs is right about where they were estimating, maybe even a little bit higher. And remember, the fiscal year for the Patent Office ends at the end of September. As of last week, they had 169 decisions to grant or deny, so they've rendered decisions. Now remember, a lot of these also are settled, so they're terminated by settlement, and therefore there's no decision to grant or deny. So there's 169 decisions to grant or deny, 145 have been granted, that's at 86%, which to me is lower than what they were doing in re-exam. But again, you know, over time, maybe a couple years, this will come back up. But if this number stays around here or even lower, that's going to be less than what you used to see with re-exams. Re-exams were granted, I think, around 93 to 94% of the time. The biggest thing, for me at least, is that only 33% of the proposed grounds are where they're granting trial. So it's a significantly reduced number. I suspect that that number will go up as people learn how to go through these and start filing multiple petitions or reducing the number of grounds that they propose. 24 have been denied outright. A bunch of these are from the same firm, and that's about 14%. So that's pretty high, I think, denial of, and this covers both IPRs and covered business methods. And 15 have been granted on all of the proposed grounds. So that's pretty low as well, only 10%, less than 10%. This next number is pretty consistent with what we've seen in the past. Around 90% of these are related to litigation or related to other IPRs. What has been happening lately, too, is that you could file an IPR within a year of when you're sued for litigation, so you satisfy the statute, the time bar of the statute. Something happens, maybe some grounds are denied, and in some instances, either a co-defendant files after a year or that same party files another IPR and requests joinder, which you can do after a year. It's not always granted, but if it is granted, then now it's joined with the other one, so it's related. 12 have been terminated due to settlement. So that's not too many either, but that seems to be a pretty big trend as well. So that's all I have for today. I don't see any questions, but obviously if you do, because I'm eager to answer any questions you have, you feel free. I have my information here to either call me or send me an email, and I will be happy to respond as soon as I possibly can. Once again, thanks for joining. We will send out the reminder for the next webinar, which will be sometime in October. And I wish everyone a good day for the rest of the day and the rest of the summer. Thanks again. Bye.